We are now live.
Good morning, everyone. Want to call to order today's meeting, CBE. Ms. Wong, would you please take roll?
Sure. James Bolton,
Here.
Robert Brody,
Here.
Michael Cow,
Here.
Alex Chen, James Efting,
Present.
Kareem Gongora, Dolores Heisinger,
Here.
Judge James Herman,
Here.
Michael Iseri,
Here.
Larry Kaplan,
Here.
Paul Kramer,
Here.
Esther Lynn, Vince Reyes,
Here.
David Torres,
Here.
Don Wilkerson.
Here.
We have a quorum, Mr. Chair.
Thank you. As noted on the agenda for today's meeting, public comments during the meeting will be limited. Members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure that the committee would have time to consider those comments. The committee has received and read all the written public comments. We thank you for that. The committee coordinator will attempt to call members of the public in the order that they appear. Due to the number of people requesting to make public comments, we ask that you limit your comments to 2 minutes to facilitate hearing as many members of the public as possible. I encourage you not to repeat points that were made by previous speakers, and to allow the committee the time needed to deliberate on the important topics that it will be discussing today. We will not be able to hear more than a maximum of 15 minutes of total public comments. With regards to logistics for raising hands, for those of you who are participating via Zoom video, you should have a function for virtually raising your hand. It's a hand icon. It should appear at the bottom center of your screen. If you wish to make a public comment, please click on that. For those of you who are participating by phone, you may virtually raise your hand by pressing *9. That's the star key, then the number 9. The coordinator will call members of the public in the order that they identify raised hands and will enable the microphones of the speakers. Ms. Wong, at this time, do we have anyone who wishes to make an open comment?
Mr. Chair, can we remind them they have 2 minutes for their each public comment?
Yes, and again, we ask that you limit your comments to 2 minutes. So you will have 2 minutes and you will be notified when that time is fast approaching.
Thank you, Mr. Chair. At the moment, we have Mr. George Leal. Mr. Leal, you may give your public comment.
Thank you, Mr. Chair, members of the committee. I appreciate the opportunity for a couple minutes of your time. I'm George Leal. I'm the Dean of the Irvine University College of Law, and I want to speak very briefly with regard to a matter on the educational standards agenda today, 0-403. It's a major change request by my school to become a distance learning program, redesignating it from a fixed facility program. This will be the probably largest fundamental change in the school's history in over 40 years. And if COVID has had any small silver linings, it's demonstrated to our faculty, to me and our students in ownership that our pathway to accreditation leads through distance learning. Very much thankful to the committee for its foresight and its empathy and understanding to give all of the fixed facility schools the waiver that we've been operating under since March of 2020, and the extensions that I understand are on the way. It really gave us the opportunity to both explore and develop methodology and now the content of what we believe would be and will be a compliant distance learning program. On that point, I want to thank Ms. Leonard personally for all of her incredible support and hard work in working with me to fine tune and present to the committee, I believe, a proposal that is fully compliant. With regard, the only major point I'd like to raise and have the committee at the appropriate time discuss is a minor change to the recommended reporting requirement that has been set out in the recommended agenda vote. And that is the original request was to have us submit all of our syllabi for each course in our entire JD curriculum by March 15th. And to be honest, that's a Herculean task that is frankly impossible. We're working now already toward our first semester as a distance learning school with the new metrics, and that'll start in July. And in conversations with Ms. Leonard and staff, I understand they now understand the burden, and we'll be able to provide the syllabi for courses, first-year courses, and those that we will be offering in our second and through fourth-year curriculum by mid-March, and then have a staggered further reporting requirement as other courses, primarily upper division classes and electives, are built out. Putting the syllabi together is frankly the single biggest challenge that we have and task that we have ahead of us. So with that minor change, thank you again for your time, and I appreciate and look forward to the vote of approval.
Thank you, Mr. Liu. The next public comments is from Megan Zavi.
Thank you. Can you all hear me?
Yes, we can.
Hi, thank you. My name is Megan Xavier. I'm an attorney who represents state bar applicants. And I want to speak for just a moment about the July 2021 exam, since the report from the director includes an item related to that. Through the saga of the online bar exams, we've obviously dealt with a host of technical issues with ExamSoft. And procedurally, those have mostly been handled through Chapter 6 notices, which have not been affirmed. So the applicants have suffered no adverse consequences. But with the July 2021 exam takers are suffering major adverse consequences due to ExamSoft's failures. There are applicants who are locked out of the exam for 30 or more minutes on an essay. Well, the bar exam can't be completed in half the allotted time, so not surprisingly, these applicants who suffered these technical failures failed the exam. And some of them still came extremely close. I spoke to one person who failed by 4 points, and they were locked out of the exam for almost an hour. The bar has acknowledged these failures of technology, but it has provided no process by which these exams can be accommodated in some way. When applicants actually reach a bar employee, it's clear that the bar doesn't really know what to do with the situation either. And so what the bar has done is offer that they can take the exam again, but not pay the fees. Now, these examinees should not be forced to take the exam again if their written submissions demonstrate sufficient learning in the law proportionate to the amount of time that they were actually given to take the exam. So I want to speak today to ask the committee to please put in place a method by which these exams can be reviewed. The state bar already knows how many students or examinees this includes. They've already identified them and offered them a free February exam. So I would ask that the committee put in place procedures for those exams to be reevaluated commensurate with the amount of time that the applicants actually had to write their exams. Thank you for your time.
Thank you. The next public comments is Maria Tai.
Good morning, Justices and members of the Committee of Bar Examiners. NCBE announced on June 1st that all February 2012 bar exams will be offered in person only. I've written to implore you to keep open the option of taking the bar exam online. While NCBE determines that in-person is the best method to administer the bar exam, its mission is to eliminate any aspects of its exams that could contribute to performance disparities among different groups. I would like to draw your attention especially to the needs of LM students and foreign attorneys. A minority group of international examinees tend to be non-US citizens. Notwithstanding travel restrictions vary across countries, the additional costs of testing and quarantining are excessively burdensome. Many non-US countries require mandatory quarantining of 2 to 3 weeks at a designated hotel after international traveling. Overseas examinees need to fly in a week earlier to adjust to the time zone. US embassies and consulates are experiencing a backlog of visa applications. Citizens of some countries, despite in possession of a valid visa, got refused entry at the US port due to political tensions. Even going through international traveling will not guarantee a sitting in the US. And we are speaking of the cost of 1 month of hotel accommodation, plus flight tickets, plus visa application fees, plus COVID testing fees. If in-person is chosen as the best method to avoid cheating, there are other ways to carry out in-person assessments locally in foreign countries, like how the MPRE have been administered this September. Having found the best method does not have to mean taking away the other options. One of the blessings of the pandemic is a chance to rethink the existing model of things. As the results of online exams are recognizable, why do we have to keep it as a backup only? The goal of diversity and inclusion in the context of a bar exam is to yield a wider access to the professional system. Being able to participate is the first step to get included. Therefore, I humbly implore you to keep open the option of taking the bar exam online. Thank you.
Thank you, Ms. Tai. The next public comments is from Rosa Mosley.
No, I accidentally raised my hand.
Oh, okay. Thank you. At the moment, Mr. Chair, we don't have any more public comments. This is conclude our public comments period.
Thank you, Ms. Huang, and thank you to the public who did share public comments. Moving on to the next item on our open session agenda is approval of the October 15th, 2021 Committee of Bar Examiners public meeting minutes. I know members have had a chance to review that. Is there a motion to approve the meeting minutes?
This is Robbie. Oh, I'm sorry, Dr. Bolton, were you going to make that motion?
Yes, so move.
I'll second Dr. Bolton's motion then.
Ms. Huang, can you take roll vote, please?
Yes. Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Kao,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora, Ms. Heisinger,
Yes.
Judge Herman,
Abstain.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Ms. Lin, Mr. Rios,
Yes.
Judge Toriaba, Mr. Torres,
Yes.
Dr. Wilkinson.
Abstain.
The motion passes.
Ms. Huang. And moving on to the next item on our agenda is a report from the director, Ms. Nuñez.
Thank you. Good morning, everyone. I'm going to start with our key statistical indicators. Our key statistical indicators report capture the number of applications received by the Office of Admissions, and this is a period for September 2021. It also notes the last year's count. And what I do is I highlight applications that experienced a 15% change when compared to the previous year. So on this, for this month of September 2021, applicants that were placed on the motion, it has a 67% difference, or 67% more applicants placed on the motion in September of this year compared to last. And I've explained this before, because it's been a consistent differentiation from last year, that this is due to the October 2020 California bar exam postponement. What this did is delay the results release to January of this year, when results release would have happened in November 2020 if the exam was held in July. So this explains that differential. As for registrations received, the attorney registrations, this is registering as an attorney altogether, received about 22% less. We've received 22% less attorney registrations in September of 2021 compared to last year. Also, the number of attorney examinations, that is the number of attorneys that are applying for the bar exam, We received 30% less applications this year when compared to last. As for moral character determination extensions, we received 38% less this period than compared to 2020. And for MJP applications, and this includes the various categories. It includes registered in-house counsel, military spouse attorneys, and registered legal services attorneys. We received 37% less applications this September compared to last. And the last category with a 15% or more differential includes a pro hoc vice applications. This year we received 24% more applications when compared to last year. All right. Any questions?
All pandemic, you think?
If some of this is related to the pandemic, Larry, is that the question?
Yes.
Possibly. This year has been consistent in the same categories, so it could be residue, yes, from events that happened in 2020. All right, then we can move on to the next item, and it's I just want to highlight the schedule for the 28th, 29th, 2022 CBE meeting. This meeting is a 2-day meeting and is considered our planning meeting when the committee revisits our subcommittee goals and establishes what we intend to tackle in 2022. Our current plan is to continue to meet via Zoom. We're going to continue to monitor safe practices for public meetings, given the growing COVID concerns. And as well, we're going to make sure that we are adhering to the executive orders around public meetings. Any questions about the upcoming CBE meeting? All right. The next item then is Provisional Licensed Lawyers Program. So these are statistics. And what I have before you here is the number of people who participated in the PLP program. We have 1,573 applicants that have participated to date. Of those, we have 308 that have been licensed via the expanded pathway. That is, they've completed their 300 hours, and they also have received a positive reference and proceeded to be licensed. Now, I've also created the demographics for both of these groups. So can we go to the next slide, please? So this is of everyone who's participated. This is the race and ethnicity of those that have participated in the program. As you can see here, the largest category are white participants, followed by Hispanic, Latino, or Spanish. Next slide, please. In terms of the law school type, the majority of participants in the program come from ABA accredited law schools in California, followed by CBE accredited law schools. Next slide, please. As for gender, there's a greater proportion of females that are participating in the program. And in the next slides, I'm going to cover those that have been placed on the motion. Next slide, please. Sorry, this is got smaller. So as you can see here, of those that have been admitted to the bar through the pathway, the majority have been white, followed by Hispanic, Latino, or Spanish. Again, this is reflective of those that also have participated. Next slide. In terms of school type, it parallels with those that are participating. So a majority have come from ABA accredited law schools, followed by CBE accredited law schools. Next, please. And then also the majority of those admitted have been female. All right, any questions about the provisional license program before we move on? All right, so with this, I'm going to hand it over to Alex and Esther, and then I will add a little bit after their presentation on the Blue Ribbon Commission update.
I don't know if Esther is here. Esther, if you are, do you want to go first?
Esther informed us she was going to be late. She's in court at the moment. So Alex, you might want to start without her.
Oh, okay. Yeah, that's fine. Let me just go through what we discussed last time at the subcommittee hearing. As you recall, I am actually now a member of the subcommittee on pathway to licensure through a licensing exam. And at the last meeting, we focused on several topics, one of which deals with how best to test for minimum competence. Really, the essential question is how can a two-day written exam, separate minimally competent candidates from those who are incompetent? That's always going to be a daunting challenge. And so what we try to do is understand, all the risks and all the awards and advantages of different parts of the exam to try to, formulate something that we can propose to the court. That being said, we have gone through a number of private and public studies, on how best to properly define minimum competence adequately. After all, that's sort of the starting point. And a lot of these studies we have read, stress that skills are just as important as knowledge in defining the minimum competence to practice law, which, if you recall, is essentially what the final report of the CAPA study said, and what they recommended as far as what the bar exam should have. And so, if I remember correctly, minimum competence based on the report should at least assess a number of things like drafting and writing, or research and investigation, or issue spotting or fact gathering, and also things like counseling, right, or advising, or litigation-related type skills, or things like communicating or building relationships with clients. Things of that nature are our core skill set that we should also test. And so, assessing some of these competencies will require new formats and approaches. And so, an evidence-based bar exam, we have to look, will be likely very different than the current version or current format of the current exam. The committee also consider other key principles in properly formulating the definition of minimum competence. For example, it should licensed lawyers be able to readily demonstrate that level of competence, because if they can't pass the bar exam without extensive study, well, it logically follows that the exam isn't really testing minimum competence, right? We also discussed whether there's a need to reduce testing based on memorization. As lawyers develop experience in a very specific practice area, they do assimilate many legal rules into memory. So another consideration is how lawyers practice, at least in the current 21st century, whether memorization of black letter law is a necessity, given that lawyers do frequently look up rules in case precedent, right? For example, I practice exclusively in federal law, so local rules and standing orders and chamber directives are things that I have to look up, even if I think I know them, because they get revised and updated every so often. So what you think is current could actually be outdated. The subcommittee also considered whether to use multiple choice of questions sparingly, if at all. Multiple choice of questions have become a staple of testing because they're so easy to grade and allow sophisticated calculations of reliability. But that comes with a heavy price tag. Right? Study shows that multiple choices are likely to reduce performance among test takers of color. And so an alternative is to reduce at least the scoring impact on the applicant's overall passing score, for example, from the current 50% to something smaller. Other topics we cover at the meeting include how replacing the essay questions, for example, with performance tests might look like, and whether to adjust the timing for all the exam components so that all test takers have an opportunity to demonstrate their minimum competence. And of course, all of these come with the ongoing commitment by all members of the subcommittee to be inclusive and fair in every step without consideration. Fairness, inclusiveness, and equity is just as essential as reliability when trying to construct a new bar-exam format. My understanding, and my personal belief, is concepts are joined at the hip, and they're simply inseparable. And so we'll continue to work, through the course of the year and around the clock, so that whatever proposal that comes out of this subcommittee, it is not discriminatory, but instead improves accessibility and diversity for all the underrepresented applicants, all without sacrificing minimum competence. And so with that, that concludes my summary, and I will hand the mic back to Amy in the chair.
All right. One thing I wanted to add here in Esther's absence is a highlight of what was covered in the non-exam pathway. As Alex noted, we have two subcommittees, and Alex is sitting on the exam pathway subcommittee, Esther sitting on the non-exam pathway. And at the last meeting, there was a presentation that was conducted by the Legal Services Funders Network, which is an organization that provides opportunities for apprenticeships for 3L applicants. What they do is they seek out 3L students who are interested in working in partnership with communities that in public interest law. So they provide grant opportunities for them to come on as employees, partner them with different organizations. What's important here is that they try to mirror the client community. As I mentioned, their area is in public interest, and so they partner with law schools to provide applications to seek these fellows who come in and work for about 6 months from graduation until bar exam results. Their compensation is equivalent to a first-year salary, and what they do is they also provide these employees some time to study in the month of July while preparing for the exam. They are supervised throughout the process. They serve as going to court. They meet with clients, and so they are part of the staff at these organizations. And so the idea is to look at this model for potential to create something like that as a non-exam alternative pathway. We have an upcoming meeting that is scheduled for December 8th, where again, the two subcommittees will be meeting. One thing I wanted to add is I want to go back to talk about what the BRC has been charged with. They've been charged to determine whether to adopt the next gen exam, to continue with the California-based bar exam, or to move to a non-exam pathway to licensure. Along with that, the Supreme Court asked the BRC to examine and make recommendations on exam modality and test delivery methods, specifically looking at the possibility of continuing with remote exams or the use of test centers, as well as the use of open book and computer-based testing. In an effort to explore the use of open book during an examination, the State Bar will be conducting a small experiment during the upcoming July 2022 exam. So we plan to add a third day of testing to examine whether the use of open book creates differential performance among the testing population, and also to look at the impact of timing. Specifically, does more or less time than the current timing impact performance? We are in the works of establishing a plan. We're working on the parameters of the experimental session. So design decisions need to be made, including determining what the incentive will be for our participants, as well as the pool of participants that are required for this. So we will keep the committee updated on these activities as we develop these plans. So with that, does anybody have any questions related to the Blue Ribbon Commission? Okay. All right, so the next update is related to the differential item functioning working group. And I believe that Michael, you will be doing the update on this.
Thank you so much. Sorry about that. I had some, apparently my laptop's touchpad wasn't being responsive enough. Yes, we met for diff last Monday. I was the lead due to circumstances of some unavailability. We had a great productive meeting. I believe we were presented a guidelines of different bullet points that range from gender, race, and other sections in terms of how we can best create and respect the different questions or the products of questions. So it will be more fair assessments that does not lead to unnecessary confusion or anger, or not really anger, but just insensitivity that we were not trying to produce at all within the questions. It's being more cautious and being more mindful of how we word questions, but also how we present different characters in the question hypotheticals and items that does not produce an unnecessary results that's not systematically or stemming from the actual question in of itself. In other words, trying to make sure our questions does not produce uncharacteristic biases, racism, anything of that ilk. That said, we will be viewing the different bullet points. I definitely love how it was mindful about the different ways of approaching and how we outline. We did improve upon some of the bullet points. Most specifically, we added in another category to the age and we added the category of age and generational gaps to the actual guidelines or principles that we wanted to implement for the bar exam questions to make sure that they're not producing unnecessary results or reactions from applicants. What I mean by the age and generational gaps is more specifically, we have different ways of interpreting it. My preference was more about concerns of implement or having questions based on items that include technology applications, when in general, I hope that applicants will know what a smartphone is and what a cell phone is. However, I don't think it would be fair assessment if we say anything more specific like an app on a smartphone, or just alluded to that it's an app on a phone itself. I think that might produce some confusion for different age groups and categories. And especially since the bar exam should be catered to all different types of ages, because we have applicants not only young-ish who just recently, went from college to law school or grad school to law school, but also we have applicants who are doing transitional job switches and roles, and that's something in which I want to be respectful of. That said, I believe the next steps, unless if Amy, you want to correct me on this, is to whether to present this to this committee for the approval or to seek approval of something else and then just then, I guess, adopt it within the state bar of California.
Yes, so Michael, you're correct. So we are finalizing what we want to present as the guiding principles, or what the working group wants to present. Guiding principles is to for methods of reducing or potentially eliminating differential item functioning in the essay questions. So I believe we're going to meet one more time to finalize it to get finalization and approval from the working group, and then it would advance to the CBE and to the board. And ultimately, we want to provide this also to the Blue Ribbon Commission.
Definitely, thank you. And so please look forward to the finalized items, I guess at either the next meeting or the meeting after that. I think we're aiming for January, but it depends on the agenda schedule and whether or not Diff can meet before the January meeting.
Thank
So
you.
thank you.
Can I ask a question about that? So
Yes.
in either case, can we at least consider at least part of the agenda, just having an update from your group again?
By all means, yes.
Awesome. Thank you.
Thank you.
All right. So we're now going to turn to a discussion of the bar July 2021 California bar examination results. Audrey and Christina Dole will be presenting on this, so I will hand this over to Audrey.
Sure, thank you. We're going to talk a little bit in depth about the July 21 California bar examination. And I think it's best to start actually with Christina Dole, our program manager for grading. She's going to go over for everyone the grading and scoring that we did for that July exam. So I think if you stop sharing, Christina will share her slideshow.
Okay, as Audrey mentioned, I'm here to give you an overview of how the State Bar handled the grading and scoring for the July 2021 California bar exam. There we go. As you know, during this exam, some applicants experienced a software freeze, which required them to restart their computer. Many staff hours were put into tracking the various reports to determine which applicants were affected by the mid-exam restart. And the software company ExamSoft turned over their reports, which cross-referenced the mid-exam restart reports against the total exam duration. The call logs from both ExamSoft and the State Bar were reviewed. And of course, any cases that came through the admissions applicant portal were also recorded into our database. After we had, excuse me, an accurate picture of who and how many applicants experienced this issue, we defined an impacted applicant as anyone that experienced this restart, whether they lost time or not. Work then started with the exam psychometrician to develop a scoring adjustment if needed for those applicants. The State Bar applied a pro-rata grading adjustment to each affected written sessions as long as not more than half of their written sessions were impacted. Relative difficulty for the question was calculated with the average score on each question among the unaffected population and the overall average of all scores. The difference in averages was used to represent the relative difficulty for each question and became the adjustment factor. Next, an average was calculated for the examinee score on the session that no issue was encountered. And then this average score combined with the adjustment factor gave the expected score. The expected score is the score that was reported to applicants on their result letters. And finally, the State Bar took unprecedented measures by offering examinees who experienced these tech issues and were unsuccessful on the exam, an exam fee refund from the July test, or a credit to take one of the 2022 exams. And with that, I will turn it back over to Audrey.
Thank you. I just want to go over that point a little more. So there were 1,298 applicants who were affected. by that exam soft memory utilization issue and did not pass the exam. And that pool are able to request their July 21 exam fees to be credited for the February exam or the July 22 exam, or receive a full refund of what they paid. We're still waiting to hear from a large percentage of this pool. About 40% have written into their applicant portal to date to let us know how they want their credit or refund handled. We've given applicants until January 3rd, so there's still time. But if applicants know right now that they want to use the credit for February 22, they are encouraged to write into their general portal, submit a general, their applicant portal, submit a general request and let us know they want to use that credit for February. Some of the test center space is limited. So if they want to get in and they know ahead of January 3rd, it would be great if they could let us know that they want to use that credit for February. And they also, of course, would have to apply for the exam itself. So they have to write in with a general request saying how they want to use their credit. And then they also have to apply. Anyone we haven't heard from by January 3rd will just automatically get their fees refunded. I just wanted to go over that and explain it for all of you, and in case anyone listening has not yet decided or has not yet told us how they want their credit or refund handled. Were there any questions?
Audrey, this is Robbie. Do those, for purposes of statistics that the bar keeps, do they still count as not passing the bar, no matter which option they choose?
Right, a credit or a refund for a future exam doesn't affect how they were counted in July.
I see. Thank you.
Anyone else? I'm looking for hands.
Audrey, I have a question. So if somebody requests the refund or a different date, I think I understand that. But for those who maybe took a portion of the test, but for some reason were knocked off, do they have to take the entire test over again, or is the sections that they took, will that be, do they have to take that, do they have to do that over again? And there was a public comment that kind of addressed that. So I don't know if it's been thoroughly thought through yet. So
you're asking if it's possible to retake part of the exam and not retake the entire exam?
Yes.
Applicants would have to retake the entire exam.
Okay.
Kareem?
Yes, good morning, Audrey,
Morning.
and thank you all for your presentation. I had a question on what was, and you guys might have discussed this, but I might have overlooked it. What was the threshold for rescoring on this exam?
In terms of how that pro rata
Yeah, because I
analysis
believe there is a threshold we utilize for a normal test, but in this situation, I believe there was a different approach taken. But I might have overlooked what that process was.
Christina, do you want to answer? I think you might be asking about the phases of. Go ahead.
Yeah, Kareem, are you asking what the regrade band is? And if that is your question, then 1350 is our regrade band. So anyone that came within 40 points of the pass line went into second read, and that is our normal regrade band. So in that way, the multi-phase grading process was the same as previous exams.
Okay, so then for the applicants that experienced those technical issues, we didn't offer any additional rescoring. We just stuck to the original procedure?
So that's correct. In the first phase of grading, for those applicants that experienced an issue and had an adjustment factor, those people could have gone into second read, but we didn't artificially put anyone that experienced the technology issue into second read.
So at this point, is it still possible for applicants to appeal for that analysis? Or are they past that timeline?
That would be a policy for the state bar to decide upon. However, that would take us outside of our regular grading procedures to artificially put a select group through a second read.
Okay. I think what my concern is, while I understand the basic procedure we follow, I think the technical, so from what I'm hearing, the protocol for those who had technical failures are to receive credit or to retake at the next session by January 3rd. Is that accurate?
To at least alert us on a decision of
Okay.
which option they choose by January 3rd.
If they want to, you know, if they just want the refund, we'll refund everyone after January 3rd. But definitely if they want to apply it to February for sure, but even to July, it'd be great to know by then.
Yeah. And see, for me personally, I think part of my concern with that is that those individuals who experience those technical failures unbeknownst to them, I think it puts them at a disadvantage if they're unable to enter that second read, but I just wouldn't know how we would tackle that, considering there's over 1,000 applicants that were within that that subgroup that was impacted. So I don't know. It just seems a little interesting, just to hear it from for me to recite. It just seems like there's a bit of an unfair situation taking place. And do we know any of the data of how many people were within that threshold? Like, let's say within 5-10 points of that 40 point.
We haven't conducted that level of analysis, Corinne. You know, what we did during our during this grading cycle is we wanted to ensure that graders treated each of our questions the way they have in the past. You know, that they evaluated each of the questions as they have in any of these exam cycles. We applied the pro rata post grading. And so in terms of going back, I think, you know, we're past that stage. And the other consideration too is, you know, the entire effort to compensate applicants for this scenario is just to address that. This is definitely a very monumental event that happened, and we're trying to recognize this by providing that pro rata post grading. So again, you know, the compensation is of that in recognition of the challenges experienced by these applicants.
Well, and
if I may interject for a moment, so that the committee knows, because these matters are matters that are currently or threatened to be part of litigation, there can be a more fulsome discussion during our closed session.
I would prefer to withhold it for the closed session if we can.
And I just wanted to make sure, Kareem, you know, that all of those applicants in their result letter were notified. You know, there was no unbeknownst to them in terms of the adjustment and the refund options. They all have that in their result letter.
Okay, thank you. I was just working through it in my brain, so I appreciate the responses. Thank you so much.
Dolores, you have a question?
Dolores, you're on mute.
There
you go.
So I'm going to ask a question and you can tell me if this is best answered in closed session. You spoke about the logs provided by ExamSoft. Do those logs verify the blank screen? Is that where the over 1,000 affected people comes from, or were these self-reports? Or were some of them self-reports and some of them verified by ExamSoft, or were they all verified by ExamSoft? And if the answer is yes, that the logs show that kind of specificity, do they also show, can they show how long a test taker was off the grid, so to speak?
So we had, and go ahead, Christina, you can jump in too, but we had from ExamSoft a variety of different, I guess, logs and reports. So they were able to give that specificity of everyone who was affected by this memory utilization issue. And the reports would maybe not say like, well, we have their call logs too. So we could see how long someone maybe was on the phone with ExamSoft, but being on the phone while you were out of the exam does not cut into your exam time, because when you reboot, you're back into the exam at the time. So we have the time that the applicant was in their session, and if they were on the phone, we know that time, but the time on the phone or waiting on the phone didn't cut into the time that someone had for their session, unless they uploaded, in which case they could request another download. So they'd start the time of that session. So I don't know if that's a confusing answer, but we do have that kind of level of drill down for applicants. And we also could see from their videos how much time they had, and then when they had, you know, clicked to submit, so how much the time they spent in each session as well.
Okay, thank you.
I wanted to also mention that, as you can imagine, it was such a complicated event that some of this is still evolving. So there will be updates or changes to some of the information as time goes on.
Yeah, I just wanted to piggyback on what Audrey and Vanessa both said, that people are still currently emailing the state bar, telling us that they may have experienced the glitch, and the state bar is still investigating these applicants that are saying that they experienced the glitch. So while the majority of our investigation is complete, and I feel that we have an accurate picture, there are still people that are asking, please look at my video, please look at the ExamSoft logs to make sure I wasn't one of the affected people, and the state bar is doing that.
Any more hands raised I'm missing? If not, it's back to you, Amy.
All right, I have a couple more items under my report. The next item is really related to the consideration to amend California Rule of Court 9.42. This rule authorizes law office students to participate, is looking at authorizing law office students to participate in the practical training of law students program. So more than anything, I want to make the committee aware that in July of this year, the Supreme Court received a petition to amend the California Rule of Court, and this governs the practical training of law students. Currently, the rule does not permit students pursuing a law career through the law office study program the ability to participate in the PTLS. The court recognizes the value of supervised practical training to better prepare attorneys for competence practice. And so the court has directed the board to study and consider whether authorizing students enrolled in law office study would be prudent. And so I bring this to your attention because this project will be discussed once more at our planning meeting in January, where we will tackle this along with our 2022 project goals. Are there any questions? Okay. The next item is about Proctor recruitment and test site acquisition and management. So in February, this next February 2022 exam, bar exam, will be our first in-person bar exam since February 2019. And one of the challenges that we've experienced is in Proctor recruitment. our proctors are, for the most part, we use a lot of retirees. And with growing COVID concerns, there's been a hesitation or reluctance to return to in-person examinations. Also, with many testing agencies around the state or country moving to using test centers or using a remote proctoring system, it's really reducing the proctor pool outside of just the bar exam. It's a pool that is shrinking at the moment. And what it's made us do is hire new proctors. And new proctors, or somebody without this experience, have been difficult to first identify and then also to maintain from one exam to the next. Our assignments are very short term, anywhere between like 3 and 5 days, twice or up to 4 times a year if we use some of that for the first year exam. So given these challenges, we have turned to an agency that recruits and supplies proctors on an ongoing basis year round. So for the February 2022 exam, we're going to be working with PSI Online, who's going to supply a portion of our applicant pool. So the State Bar will be administering that exam, Office of Admission staff. That is, aside from PSI bringing on a portion of our proctor pool, we will be conducting all the training and administering the exam as usual. PSI Online will be shadowing State Bar staff during that exam, with the idea of providing input on where we can gain efficiencies in our exam administration process. Once we are completed with that exam, PSI will also start providing our test sites. So for the July 2022 exam, idea is that PSI would be providing 100% of the proctor pool, along with selecting our test sites around the state. In January, we're going to remind all CBE members again to come and visit our test sites in February. It's a great opportunity for you to observe how the exam administration is carried out. So I want to give everybody an update on how the proctor recruitment and test site acquisition will change. But this does not prevent the committee from coming to these bar exam sessions. Any questions?
Amy, this is Robbie. Wow, this is so interesting. So are we talking about, say, not using the Pasadena Convention Center anymore and our other traditional facilities for administering the exam?
Potentially. We are going to rely on PSI, like I said, who does this year round, to identify. They may or may not use the same testing sites, but they will be soliciting for that on behalf of the State Bar.
Oh, wow. It sounds like this would be significant. This would be an additional cost to us doing this in-house. It sounds like they're doing what the bar has been doing, plus we're paying them for their administration.
Correct.
Oh, wow. Thank you. And Amy, would they also be administering the ADA accommodation applicants with their special timing and needs?
Yes, and they have done this for other exams outside, obviously, of the bar exam. So, we would be working closely with them in terms of needing to provide, our obviously our list of candidates, their needs, our processes, and the rules that we use during all of the exam administrations at standard test sites and at test and accommodation sites.
Thank you.
Sure. All right. So with that, I will hand it back to you, Alex. Thanks, everyone.
Thank you. And I believe now we're going to shift to a presentation based on the scheduling of our guests. The presentation is going to be on post-traumatic stress disorder. And I'm going to turn it over to Ms. Tara Clark to introduce our guests.
Morning. Thank you, Alex. And let's see. It looks like, Kim, have they already been promoted?
Yes, they are.
Perfect. Thank you so much. So good morning. Thank you, Justice Moore and Dr. West for joining us today. So as part of the ongoing series of trainings for the committee, and at the request of the committee to fulfill its role in conducting administrative reviews of moral character determinations, we have Justice Eileen Moore and Dr. Kathleen West here to talk to us today about the dynamics of post-traumatic stress disorder and the related conditions. So with that, please welcome them today, and I will begin sharing my screen for them in one moment. Okay, thank you.
All right, thank you very much. So I am really pleased to be here today. I want to thank you all for your interest in this topic. And I think, do I have capacity to just move the slides forward? Is that right, Tara?
If you'd like to share your screen, then you can do it. Otherwise, currently I can do it for you.
No, go ahead. That's fine. If you can just go to the next slide. I'm going to jump right in. So I'll tell you just a tiny bit about myself. I'm an epidemiologist by training, and after this year, you guys know what epidemiologists are. I'm not a skin doctor, although in the past that used to be a question, but I work with epidemics, not infectious disease type, but I work with addiction, intergenerational trauma, traumatic stress, suicide, the kind of social determinants that we're seeing manifest tremendously. And today we've been asked to talk about the dynamics of post-traumatic stress disorder and related diagnoses. So these are the learning objectives. I want to let you know I'm going to go actually quite fast through the slides, which I think will be available to you after this presentation. And I'm the first presenter of two, and we hope to have some time for questions as well. So the goal today really, these are my learning objectives, is to understand and describe aspects of PTSD, related conditions, including traumatic brain injury, military sexual trauma, to identify and interpret the relevance of PTSD in the context of your role as a member of the appellate body for moral character determinations of the committee bar examiners, and then to understand and apply the California law in the context of veterans and PTSD and related conditions. And that's Justice Moore's bailiwick, and she will apply you with that information a little bit later. Next slide. So just to set the stage, you may already know this, but a lot of folks don't realize that California has more military installations, veterans, and National Guard than any other state. We have 26 active military installations and about 2 million veterans, and the biggest National Guard in the United States, many of whom are also veterans. They transfer from active duty service directly into the National Guard. Next slide. This is a map of veteran population from data from 2018, I believe. That's the most current fiscal year map that we have. You can see California is heavily loaded with a lot of veterans throughout the state, concentrated a lot in Southern California. Next slide. And just a reminder that while we've been dealing with the war for quite some time, less than 1% of the US population are in the US Armed Forces. And therefore they've been heavily deployed over the last 2 decades. And it makes for a unique population with challenges that we sometimes don't see in the civilian society. So next slide. This is probably known to you, but we have both short and long-term problems from the longest war in the United States, which is coming to a close, at least in some stage of it right now, as we've seen in Afghanistan recently. But post-traumatic stress and post-traumatic stress disorder, which are distinct from each other, have actually been characteristics of veterans of every war. Addiction often is involved. Various degrees of stigma are associated with being a veteran. Oftentimes there are family problems. There is also oftentimes justice involvement, not necessarily as folks that I want to coming before you to enter your field as colleagues, but sometimes as defendants. PTSD includes intrusive memories, nightmares, feeling numb or detached, sometimes real dissociation, difficulty sleeping, depression, hypervigilance, and hyperarousal. And I think it's significant to note that the most recent survey that we have of firearm ownership, which was from 2015, a national survey, that's quite good data, showed that nearly half of all veterans owned at least one firearm, typically a handgun and a long gun, and the majority of them cited that the reason for owning the firearms was protection. That actually anecdotally has risen, and there are a lot more veterans with firearms in their possession. And that can sometimes be foreshadowing of the rest of our presentation here. It sometimes can be a challenge to manage in the context of PTSD, which can be treated and managed, but without treatment, it can become chronic and it can also be relapsing. Next slide. This is just a kind of a reminder that this has been with us for a very long time, going back to pre-Napoleonic Wars. The concept of what happened with stress reactions of folks in combat settings was a railway spine in the American Civil War. There's a lot of literature actually on that. Shell shock was World War I, fatigue or hysteria. It was also perceived as a personality disorder or weakness, so people didn't talk about it in World War I. And then post-Vietnam War is when it actually came into DSM, into Diagnostic and Statistical Manual parlance as a diagnostic disorder, a post-traumatic stress disorder, considered a combat stress reaction. That's where we are today. Next slide. So just a reminder, trauma can be induced by experiences that lead to abnormally intense and prolonged stress responses. In the civilian community, the largest source of PTSD is actually automobile accidents. And for women in the United States, it's actually sexual assault. But there's a traumatic event, a prolonged stress reaction happens in the body that doesn't resolve, and it actually alters your brain. Your neural systems are changed, and you become typically more reactive to subsequent events that remind you of that traumatic event. So it can also be a direct experience, or it can be secondary by hearing about it or by bearing witness to the events themselves. Next slide. This is something that's used actually a lot by the military to talk about what the response ought to be in combat operational stress kinds of contexts, that you're kind of good to go, you're ready, you may be reacting. We don't want people to get into a situation where they're injured. We certainly don't want them to get into a situation where they're ill, but that happens pretty often. So this is just something that is a key to help service members understand what the reactions might be. Next slide. And this is what also happens when you have unhealed stress injuries, trauma, fatigue, grief, betrayal, or what's sometimes called moral injury. Happens, moral injury, we'll get to a little bit later, but it happens quite a bit around military sexual trauma. And can lead to, all of these can lead to depression, other kinds of anxiety disorders, misconduct sometimes, and sometimes ill-advised coping mechanisms that might include alcohol or drug dependence or addictions. Next slide. So if I were with you in person, I would ask for a show of hands, which I'm not going to do here because I won't be able to see you all necessarily, even though I've got a little Hollywood squares going on in front of me. But you can look at this yourself and assess whether you think this guy is painting the house white or is he camouflaging it. And he's clearly not in a military uniform. But probably most of the time people think he's camouflaging the house. And because I've worked in this field for quite a long time, and I have to remain optimistic, therefore, working in this arena, I think he's painting it white. And I'm looking at that as the idea that he can kind of shed some of that military experience. But this slide is, I think, a good kind of reminder that post-traumatic stress disorder or military experiences don't just affect an individual typically, they affect an entire family, oftentimes entire communities. And we can elaborate on that, but it's important to just note that this can have lasting effects. Next slide. So I am not going to read all these slides. And again, as I mentioned, I put this here so that if you have questions or want to refer back to some of these more technical or detailed, clearly detailed descriptions of what the major domains are of PTSD, you can look back here. So it's re-experiencing, hyperarousal, excuse me, and avoidance. Next slide. The DSM-5 PTSD was revised recently to say that it required one new thing, that avoidance has to be an element, and that can also have implications for care-seeking behavior. We see that a lot of folks don't necessarily seek the care that they need for various reasons. Next slide. Just that these are some of the things that have also been changed, is that it used to say that a traumatic experience required that there was a sense of helplessness or horror, and that was removed because oftentimes people go numb very quickly and they don't have that. They found that that criteria didn't improve diagnostic accuracy. Next slide. So when PTSD was initially determined to be a psychiatric diagnosis, it was thought that traumatic exposures were very rare, likely to be infrequent events. We now know that that is absolutely not the case, that there is really a hidden epidemic of traumatic exposures that maybe is even endemic in our population. And it may be at the root of many disorders, all of the ones that are cited here, which I won't elaborate on, but things like the Michigan school shooting, which while it killed 4 people and injured 7, the prosecutor in that state is being very keen to comment that an entire community and many, hundreds of young adults and children have been pretty traumatized by that event. So those kinds of things are not infrequent in our society right now. Obviously, COVID has made things even more intense. So we really are concerned about this and the mental health of our communities. Next slide. So these are just some of the prevalence estimates in specific populations, really kind of just reinforcing the previous slide, saying that this is pretty common and that not everyone resolves after being exposed to trauma. They have ongoing problems. Also, it's not randomly distributed in the general population. It tends to happen in our more impoverished, underserved communities. And we know that stress injuries, which are kind of sub-diagnostic categories, they happen in more frequently than PTSD. Next slide. Sorry, yeah, just that there's the next little bit here is that there's an overlap of post-traumatic stress disorder, traumatic brain injury, and chronic pain. And what we see is that they reinforce each other. Basically, they're interactive, so that chronic pain and PTSD, if you're in chronic pain, you're more likely to remember your traumatic event, and traumatic brain injury tends to overlap quite a bit with both of those. Next slide. So the reason I'm mentioning TBI is because there's a lot of confusion and diagnosis between PTSD and traumatic brain injury. And there's a whole array of TBI, mild MTBI, which sometimes used to be referred to as a concussion, is really quite common and it's very underdiagnosed. But TBI is probably the signature injury from this last 20 years of our wars in Iraq and Afghanistan. Next slide. Yeah, got ahead of myself there. It is a signature injury, and it also happened a lot because of roadside bombs and traumatic blast injuries. So it's something that I think is significant to note because of the inhibitions that happen sometimes with PTSD. You see this here as well with TBI, and this can happen from your high school football player or who's had, serious concussions repeatedly, where there are emotional regulation problems that can find that there's poor impulse control, anxiety, inability to read other people's intentions, and some processing problems sometimes that can be problematic. So it's really important to get good diagnoses and to distinguish TBI from PTSD when possible. Next slide. Just that there's a spectrum. We do see that there are, when frontal lobe injuries happen, which is pretty common, and you see higher impulsivity, sometimes aggression, a greater incidence of, and these are all, this could be a 2-day session here, just this one slide. There's really a lot of things that happen here, but we do see a higher incidences of suicidal ideation and suicide attempts in this population as well. Next slide. There's a lot of difficulties in recognizing TBI. It's not easy to diagnose. Next slide. They cannot be diagnosed with an MRI or a CT scan. You have to have a diffusion tensor imaging technique, which is different than just a standard MRI. So these often go undiagnosed. Next slide. Military sexual trauma is one of the things that we also see a lot of challenges with, and many of these folks do have PTSD. Just to be clear, there is a form of art around military sexual trauma. It's used by the Department of Veteran Affairs to refer to experiences of sexual assault or repeated threatening sexual harassment that a veteran experienced during his or her military service. While we tend to talk about military sexual trauma often in reference to women, there are actually more men that have been sexually assaulted in the military, partly because there are more men in the military than women. However, the rate of MST, so the percentage of women that have experienced it in the military, is much higher than the percentage of men in the military that have experienced it. Next slide. It's not an isolated problem. It's oftentimes embedded with a complex of problems. Oftentimes there are some of these can exist prior to military service. So the reason I'm mentioning this is it can be challenging to treat. It may be associated with some chronic pain that persists, and chronic pain is seen more often in this population if there is childhood abuse as well. Next slide. Just recognition that the DoD has a slightly different definition of sexual assault in the armed forces. Next slide. The impact of military sexual trauma also varies quite a bit, but oftentimes they end up having ongoing acute problems and PTSD. Next slide. These are some of the ongoing challenges that we see in this population that have been associated with military sexual trauma. Next slide. Again, a list of unfortunate common symptoms and problems associated with MST. Next slide. There's a high correlation of MST among women especially, and homelessness. And part of these are some of the reasons why is that they tend to be more self-reliant, tend to not seek care, tend to not trust people. So these are some of the barriers to them accessing services. And the number of female veterans that are homeless is much, much, much higher than the population of other female civilians than, and MST can oftentimes be at the core of that issue. So next slide. These are some complicating aspects of MST, which was around institutional betrayal being a leading factor. Next slide. So I just want to, we're going to another few slides here, and I will move this on to Justice Moore. But this is one of the questions I know that folks have asked about, especially with regard to moral character determinations, especially if you're looking at a veteran with PTSD, for example. Are veterans more violent? Why, what, and how? Some of this information may help, the previous information may help you to understand this. But there's a lot of variability. Firearms actually are an element of why you see more violence in this population. There is higher lethality, and most often it's self-directed. So suicide among the veteran population, as you probably all know, is significantly higher than in the general civilian population. Next slide. This is a really interesting thought, and as a formerly infectious disease epidemiologist, violence really operates in much the same way. It really ends up, obviously it's not an infectious agent, but it is transmissible. Those that are chronically exposed to violence were 30 times more likely to engage in violence. Obviously, if you're in a war zone for long periods of time, you are exposed to a lot of violence. Being both a perpetrator as well as a victim of violence actually leads to more violence. There's also a dose dependency. So the more you're exposed, the more likely the violence that you may be engaged in may become more intense. Intimate partner violence, child abuse, community violence, suicide, etc. Next slide. So what we do see is that most veterans that are returning do not become violent or abusive. Most do not develop PTSD. However, those that do have consistently been found to have higher incidences of domestic violence or more general violent and aggressive behaviors than those without PTSD. That said, most individuals with PTSD, those in car accidents or survivors of rape or whatever, are not violent. So I want to clarify that, but this combination and this kind of Venn diagram that you might be able to imagine means that veterans with PTSD do actually have a higher incidence of violence. Next slide. Homelessness may be some of the reasons. If they are charged with domestic violence and are given a temporary restraining order, means that they end up becoming homeless, one or both of them, oftentimes because they can't afford rent. What we also found is that in terms of, actually RAND recently did a study looking at mass violence and domestic violence, and found that veterans were more likely to be involved in that. And that also, as we know with the suicide, almost 50% of completed suicides in the veteran population was because of domestic violence situations or intimate partner problems, and it was greater than any of the other problems that they were self-identified with. Next slide. So these are some of the reasons why you may find that somebody has a history potentially of domestic violence or allegations in their record, because they have been trained in violence with access to firearms. They typically are in the age category where we do see more violent altercations and intimate partner violence. Alcohol is often involved in those. And there can be challenges in a domestic or intimate partner relationship because of the deployments of the military service itself. Next slide. Just a very brief study a while back showed that more than half of the veterans in state prison were serving time for a violent offense compared to others, and also higher incidences of sexual assault that included rape. Next slide. I put this last bit around the violence because I think it's really important for us to put in, to recognize, not sort of whitewash that doesn't exist. But I hope that the prior on slides gave you some context for that, and the fact that this is really a responsibility that we need to manage as a society. It's not something that happened without our support of their multiple deployments over the last 20 years. So I will turn this over to Justice Moore to address the legal matters on this, and I appreciate your attention. Thank you.
Thank you very much, Dr. West, not only for today, but for your continued assistance and advice to the Judicial Council and its staff. But most of all, thank you for caring about those who have served. I am Eileen Moore. I sit on the California Court of Appeal, the 4th District. I've been here since the year 2000. Prior to that, I sat for about 11 years on the Superior Court. And long before I was Justice Moore or Judge Moore, I was Lieutenant Moore, and I served as a combat nurse in Vietnam. And that probably is the source of why I'm so interested in veterans issues, because I saw the way this country treated our veterans when they returned from Vietnam. For around when my term on the Judicial Council ended in 2008, I had made some contacts, and through those contacts, I was able to launch the Veterans and Military Families Subcommittee for the Judicial Council, and I have been chairing that subcommittee since that time. And during this period of time, for years, I hounded the state bar to provide some kind of education on veterans issues. Finally, one of my missives crossed the desk of the then state bar executive director. As a result, and it took years, as a result, the state bar, soon to be CLA, established a military and veterans committee. Dr. West and I made a presentation to the bar examiners in 2017, and then in 2018, made another presentation to this group. The reason I had been hounding the state bar is that lawyers throughout California were wallowing in ignorance about the invisible wounds and grief carried by many of our returning veterans. The issue hit home when one of the vets I was mentoring in one of California's veterans treatment courts was denied admission to the state bar after he had gone through hell and back, returned home, graduated from law school, passed the bar exam, and then committed a crime when a drunken neighbor loudly vomited on the front door of his apartment as he and his wife were eating dinner. In my opinion, it is important that all lawyers in California have at least a minimal understanding of the situation of returning veterans. And by the way, and there's about 200,000 of them in California, and they'll appear in courts and in law offices in many different ways. And by the way, one of my dreams is that the state bar will require continuing education hours specifically devoted to veterans issues. Both the California legislature and California courts have done a lot in the past 15 years to try to address some of the issues Dr. West just discussed. What Dr. West told you is the basis for much of what has been happening in California law. I am not going to presume to instruct you on how you should or could apply what I'm about to say, mainly because I have only a general understanding of what you do. Instead, I will tell you what is going on in the law and leave it up to you to decide if and how it applies to your mission. I am only going to discuss 4 statutes. I also have a few other tidbits about ongoing issues that might interest you, in that they might fill in some information about why matters continue as they do. And if I have time, I will tell you about those as well. The term post-traumatic stress disorder was coined by VA Dr. Jonathan Shea in the 1980s. And as you just heard, prior to calling it PTSD, the malady had been many other names such as shell shock and battle fatigue. Whatever its names, scholars tell us that ancient texts such as the Iliad and the Odyssey refer to returning warriors who felt betrayed by those in power, experienced deep alienation, and suffered from survivor's guilt. So the first statute, as you can see on your screen, is Penal Code Section 1170.9. When those who served in Vietnam suffering from the malady returned, we did almost nothing for them. Nonetheless, Vietnam vets, through Vietnam Veterans of America, and I'm a lifetime member, managed to convince the California legislature to enact Penal Code Section 1170.8 in 1982. It was renumbered 1170.9 in 1983. And there that statute sat for 23 years. Not a dime ever attached to it. No courts set up any special program under the statute. But when homeless Iraq and Afghanistan veterans began appearing in our streets, the California legislature put a little meat into 1170.9 in 2006. It was then amended several times, and it's been amended many times since 2006. This statute was the only game in town for veterans accused of a crime for many years. And as you can see from this screen, to be eligible, the veteran had to have been suffering from sexual trauma, traumatic brain injury, post-traumatic stress disorder, substance abuse, or mental health problems stemming from military service. The defendant under this statute has to suffer a conviction, either by plea or trial. So usually they plead guilty, and the defendant, whatever the offenses, and most offenses are covered under this, the conviction must render the defendant probation eligible, so that there's crimes such as murder and many kinds of sexual molestation, child molestation don't qualify under this statute. The purpose is to restore the veteran to the community of law-abiding citizens. And it's this last, I don't know what you call it, a pointer bullet, that I think might be most of interest to you. The defendant is not obligated to disclose the arrest, the dismissed action, or the dismissed conviction. When information concerning prior arrests or convictions is requested to be given under oath, affirmation, or otherwise, the defendant may indicate that the defendant has not been arrested when the defendant's only arrest concerns the dismissed action. So I suspect that sometimes some of you may be asking someone who is a member of the bar or who is applying a question about arrests or convictions, and please be aware that that is there. I want to move on to the next statute. It's Penal Code Section 1001.80. As of January 1st, 2015, veterans who committed misdemeanors are eligible for diversion. That means that after they are arrested, they are diverted from being prosecuted. So unlike 1170.9, this statute does not apply to felonies, and the veteran need not suffer either a prosecution or a conviction in order to receive treatment. In allowing the offender to join a rehabilitation program instead of being prosecuted, 1001.80 permits an accused to clean up and avoid a record of criminal conviction. This statute is referred to as military diversion. To be eligible, there are two requirements. First, a defendant was or is a member of the United States military. And second, the defendant may be suffering from sexual trauma, traumatic brain injury, post-traumatic stress disorder, substance abuse, or mental health problems as a result of military service. And this last bullet, I think, is even stronger than the one in 1170.9, and please pay close attention to it. The defendant may indicate in response to a question concerning his or her criminal record that he or she was not arrested or diverted for the offense, except when applying as a police officer. A record pertaining to an arrest resulting in unsuccessful completion of a diversion program shall not, without the defendant's consent, be used in any way that could result in the denial of any employment, benefit, license, or certificate. I'm waiting because I want that to sink in. let's go to the next statute, please. 1170.91. For many years, under 1170.9, sentencing courts have been required to consider a veteran's military-related conditions as a factor in favor of granting probation. But as of January 1st, 2015, under Penal Code Section 1170.91, even when probation is denied, sentencing courts must consider a former or current service member's sexual trauma and the other maladies that may be a result of his military, his or her military service as a factor in mitigation when imposing a determinate prison sentence. Maybe. Since most statutes are prospective and not retrospective, concerns arose because many veterans suffering from those conditions were already in prison when Section 1170.91 went into effect. So the sentencing judge may or may not have considered those conditions as a factor in mitigation. Thus, an amendment is subdivision B was enacted and as of January 1st, 2019, veterans who were sentenced prior to 2015 were permitted to request resentencing if the condition was not considered as a factor in mitigation at the time of sentencing. If you could go to the next page, please. I'm not going to discuss these cases, but I just want to show you that there are a number of appellate cases that have come down as a result of that subdivision B. That is the veterans who are sitting incarcerated and they're coming back to court asking for a lower sentence as a result of one of those qualifying conditions. And there's a lot of little intricate points of law. I'm not going to go into them, but I'm giving them to you in case any of you are interested in them. Let's go to the next statute, 858. This statute, the Penal Code Section 858, this statute is the state's original arraignment statute that has been in effect since 1872. As of January 1st, 2015, it was amended for the first time. The legislature must have realized there was a problem getting the word to veterans that there were laws passed specifically to benefit them. Thus, the amendment to 858 requires judges in arraignment courts to inform defendants there are certain provisions of law specifically designed for individuals who have active duty or veteran status and who have been charged with a crime. And that defendants who are active duty or veterans may request a copy of the Judicial Council form that explains those rights and may file that form with the court so that the defendant's active duty or veteran status is on file with the court. By the way, that form is MIL 100 and it came out of my subcommittee in 2009. And it was when the legislature amended 858, they directed the Judicial Council to make additions to the form, and those additions are on the back. It's a one-page form, and those additions are on the back of the form, and those additions are basically what I have just told you about these statutes. Thus, every single defendant arraigned for any crime in California is supposed to be told that if he or she serves or has served in the military, information about statutes beneficial to them is available in the courtroom, and all they have to do is ask for it. I have some other information I'd like to give you because I think it might fill in some of the questions you may have about why these veterans issues continue to plague us. But I'd like to see if anybody has any questions of me regarding any of those statutes before I move on. Tara, you'll tell me if there are any questions because I don't even know where to look for them.
Yes, I'm not seeing any at the moment.
Okay. There's a few things that I wanted to tell you. The first one has to do with the Ferris Doctrine.
And you've probably heard that a lot, and some of you may be very familiar with it, but some of you just may kind of recognize it. The United States government enjoyed sovereign immunity until the enactment of the Federal Tort Claims Act in 1946. The statute was passed after a military plane maneuvering through heavy fog in Manhattan in 1945 swerved to avoid the Chrysler Building and went straight into the Empire State Building, causing the loss of many lives and immense property damage. Thus, when Army Lieutenant Rudolph Ferris was killed in a barracks fire resulting from negligence by the military shortly after the FTCA went into effect, his family could make a claim against the military, right? Well, the lieutenant's family tried, but when the case reached the United States Supreme Court in 1950, the court created the infamous Ferris Doctrine. In Ferris versus the United States, you have this site there. The High Court held that despite the FTCA, the government is not liable for injuries to members of the armed forces sustained, quote, in the course of activity incident to service. It is the Ferris Doctrine that so frustrates advocates for service members who were sexually assaulted in the military. Criminal proceedings in the military are most difficult, and criminal proceedings by civilian prosecutors are not permitted for something that happened in the military. That should leave civil actions, but the Ferris Doctrine prevents them. If a sexual predator knew his military pension and other assets were at stake, surely he'd think twice before assaulting someone. The 2020 National Defense Authorization Act authorized, so it was last December's act, authorized members of the uniformed services to file claims for personal injury or death caused by the Department of Defense healthcare providers. A few months ago, the DoD finally issued regulations for that claims process. And Tara, did everybody get that, what you had on the screen for me a few minutes ago? Did you send that out to everybody?
Yes.
Okay, so you have the second bullet on that is just tells you where you can find those new regulations regarding medical malpractice by active duty members in the military. And I'm only pointing all this out to you because it has taken 7 decades to see this first tiny little crack in the Ferris Doctrine. The new regulations definitely favor the House, and it's doubtful that many active duty service members will collect anything from the military, but a crack is a crack, and this is the first one that there is. So you'll probably be hearing a lot more about the Ferris Doctrine and about sexual assaults pretty soon. The next thing I want to talk to you about is a particularly sad part of the process of locking up veterans who were injured in the military. It is that the VA does not provide treatment for conditions they developed as a result of military service while they are incarcerated. With all that time on their hands, veterans could benefit from intensive treatment and be better able to meet their responsibilities when released. Why doesn't the VA treat incarcerated veterans? Well, the agency decided to pass a regulation and assume a practice of simply not providing any medical or mental health treatment to veterans who are incarcerated. The VA's regulation leaves it up to jails and prisons to provide care. The enabling statute from which the VA was able to pass that regulation, in that enabling statute, Congress told the VA that it did not have to provide medical care if some other governmental entity had a duty to do so. Well, the VA's regulation not giving any care whatsoever any treatment whatsoever makes sense from a fiscal standpoint. From a moral standpoint, I think it's disgraceful. These vets signed up to serve and with the premise that their country would provide treatment for line of duty harms. Jails and prisons have no duty to provide the kind of specialized care injured vets need. The VA's regulation seems reasonable if care of the inmate involves a bone fracture or an emergency appendectomy. But when the prisoner has traumatic brain injury resulting from an explosion or PTSD after being raped, how is the typical prison doctor or nurse capable of appropriately responding? Ask the same question about a small town jail, and the whole notion is preposterous. It's really only the VA who has the wherewithal to treat the maladies suffered as a result of war. And I say shame on the VA for not providing needed therapy and other treatment to incarcerated veterans for injuries they suffered in the military. The last thing that I want to mention to you is the fact that our country is deporting many veterans who have served. Oh no, I wanted to tell you one more thing first, and that is class actions. I forgot about this. From the Revolutionary War until 1988, there was no judicial review whatsoever for veterans who were denied benefits. The VA operated a closed shop. So a veteran denied benefits was shuffled from one part of the VA to another, but no court ever reviewed what the VA did. Then in 1988, Congress created a new court, the Court of Appeals for Veterans Claims, CAVC, remarking at the time that the VA stands in, quote, splendid isolation as the single federal administrative agency whose major functions are explicitly insulated from judicial review. Until 2019, the ability to file a class action against the VA was not recognized. Class actions came to the CAVC in 2019, just as the word on the street was that the VA was engaging in a sort of catch and kill dynamic that prevented the development of the law. That is, a veteran would go through all of the VA's lengthy internal processes and then wait in line for a few more years to come onto the CAVC's calendar. Shortly before the matter was to be heard, the VA would settle the case, dooming the prospect of the CAVC setting precedent. The list of class actions presently filed against the VA, and there are scores of them, are found on the website that I gave you. In my opinion, having class action lawyers nipping at the heels, at the VA's heels, will likely bring more benefit to veterans than a barrel full of government regulations. The last matter is deporting our veterans. The Veterans Naturalization Assistance Program, VNAP, estimates there are over 100,000 non-citizen veterans in the United States. No one seems to know exactly how many persons who served in our armed forces have been deported after they were discharged, but the estimates are in the thousands. United States Immigration and Customs Enforcement, ICE, sometimes waits for troops to return from deployment and separate from the military, then meets the non-citizen at the airport when he's on his way home and places the new veteran into removal proceedings. Many non-citizens who served in the military believe they are automatically citizens by serving. That is not surprising, as the military oath and the oath of citizenship are very similar. At a USC symposium on the topic given a few months ago, Senator Tammy Duckworth described one former soldier who did not realize he wasn't a citizen. He had twice been deployed to combat zones. He was on his way to the doctor for treatment of his post-traumatic stress disorder when he was arrested, placed in a holding cell, and then deported. At the symposium, we were informed that both the Department of Defense and the Department of Homeland Security continue to oppose medical benefits for deported veterans. The documentary film Ready for War, about the impossible situations of deported veterans, has some scenes in a shelter in Tijuana, officially called Deported Veterans Support House, but commonly known as the bunker. An upside down flag signifying distress in the military is painted on the wall. The names of deported veterans are listed next to it. The impact of the denial of veteran medical care to our non-citizen veterans in one scene is heartbreaking. One deported vet at the bunker who worked with prosthetics in the Navy is shown trying to fit another deported veteran who lost his foot in the service with a prosthetic. As the impression of the stump is taken, one can see the angry pink skin just below the ankle. The D word for a veteran who is a citizen and commits a crime is diversion. The D word for a non-citizen veteran who commits the same crime is deportation. And that's all I wanted to tell you, and we'd like to leave it open for any questions any of you may have of us.
And Judge Herman, did you have a question?
Yes, first of all, Justice Moore, thank you so much for your service. I just to add something, I was a Vietnam era veteran myself, but I never served in a combat zone. So again, thank you for your service and for your support of veterans. And I just add as another resource, if we do have a statewide network of veterans treatment courts who enforce most of the statutory provisions that Justice Moore led us to. If you just go online and go and search Veterans Treatment Courts California, you'll come to the Judicial Council website that lists all the information anyone needs to know about our veterans treatment courts and what the requirements are to be admitted to the court for someone that's charged as a veteran with a crime, as well as additional resources and information for veterans' families, justice involved, other resources for justice involved veterans, et cetera, and then general resources for veterans. So it's really a terrific website for information relating to both the statutes and programs that Justice Moore has talked about, as well as veterans treatment courts in particular. So again, thank you, Justice Moore, for all of your service.
Thank you, Judge. There are 34 veterans treatment courts in California at this time.
Thank you. And Dr. Cow?
Yes, Justice Moore, I really wanted to commend you and thank you so much for your service as a Vietnam veteran. I myself was United States Air Force active duty, serving in combat Iraq, Afghanistan myself, and I really appreciate because we do not have enough advocates for veterans. And I actually did not know until the presentation today that we have 1.8 to 2 million veterans in the state of California. So I am feel so fortunate that you represent us, Justice Moore, and thank you so much for all your service and your time.
Thank you, Doctor. This group, I would hope that at some point you will discuss the need for education of California lawyers regarding these veterans issues. I don't know how it fits into what you do, but I hope at some point you can fit it in. And it's going to take somebody who really cares to push it. Anything else that anybody wants to ask or say?
Looks like Mr. Torres.
Yes, thank you. First of all, I want to thank you, Justice Moore. I've seen your presentation several times.
when I was a trustee from the state bar, but I too am a retired Army officer, former infantry officer and a retired JAG, but we just celebrated our 10th year with our veterans program here in Kern County. And with respect to the immigration issue, I think it's very important. We started during the COVID period a volunteer group of service members who are assisting California Army National Guard members to become citizens of the United States. We had a total of 237. We've completed over 50 citizenship packages, and over 50 have been naturalized. So the process is still continuing, and we volunteered our services to the deported services organization.
That is really interesting. I'm going to contact you over that. I'd like to hear more about it.
Sure.
Anyone else?
Not seeing any other questions. Thank you so much again, Dr. West and Justice Moore, for being here with us today.
Goodbye, everyone. Thank you.
Yeah, thank you again. That was a fantastic presentation, very informative. I would like to go back on our open agenda item to a couple areas that I think before we take a break, I think we can cover. So going to examinations, open item 200, approval of report on the 2021-2022 examination goals. Dr. Cal, can I call on you?
Yes, thank you so much. So this is the agenda item, as Alex had mentioned, 0200 for December 2021. We're looking for approval of the reports on the 2021-2022 examination goals. I just do want to highlight a couple, I think, very interesting things. We are going to have a training session in January of 2022 on subject matters for principles of scaling written test scores. And then subsequently also have additional training in June of 2022 on the substantive issues in determining accessibility and disability, which I think is really pertinent for the examination subcommittee. So I'd like to see if anyone would be interested in making a motion for approving the report on the 2021-2022 examination subcommittee goals that are listed above.
So move.
Moved by Ms. Heisinger, and I'll second. This is Robbie Brody Kim.
Juan, can you take a vote?
Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Judge Herman, Mr.
Yes.
Iseri, Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Mr. Reyes,
Yes.
Mr. Torres, Dr. Wilkinson.
Yes.
The motion passes.
Thank you, Ms. Wong. And we'll move on to one more before we go to the break. It's open agenda item 300, approval of report on the 2021-2022 operations and management goals. Can you please present?
Was that me?
Yes.
Sorry, I missed that. My phone just buzzed. Okay, so this is Jim Efting, the open session 0300 or 0300. There isn't really much new on this. We're going to do kind of the same things we've been doing every other month. There are some things that are going to happen late next year in June, August, and in August of next year that you might want to look at it. But I don't really see anything that needs any particular detail unless somebody has questions about the goals for this next coming year. Does anybody have any questions? If not, then I'd ask someone to make a motion to approve the operation and management goal as set out.
So moved.
And this-
Second.
I'm sorry, who is that? Mr. Reyes
Yes.
And then seconded by,
For the motion.
I'll
I
second
believe
it.
that was Provisional.
thank you, Mr. Isari. Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger, Judge Herman,
Yes.
Mr. Isari,
Yes.
Mr. Kaplan, Mr. Kramer,
Yes.
Mr. Reyes,
Yes.
Mr. Torres,
Yes.
Dr. Wilkinson,
Yes.
the motion passes.
Thank you, Ms. Wong. So it's 11 a.m. or 11:01. Let's return at 11:10 a.m. And when we return, we will continue with ed standards. So please return at 11:10 a.m.
I have a quick question. Do you know
Yes.
approximately what time may lunch break be? I'm just trying to schedule that with my law firm to do a meetup with someone else.
Sure. There are a number of items on ed standards I'm sure you've seen. So we have on the schedule lunch break at 12. So should have a good idea. I think we can meet that 12 o'clock timeframe, if not
Awesome.
sooner.
Thank you.
All right. Thank you. Okay. Thank you, everyone. See you back at 11:10 a.m. Okay. Welcome back, everyone.
Every year.
So I'm looking to see if Mr. Kramer is there, and he is. So we are going to start with open agenda ed standards. So with Mr. Kramer, I'll turn it over to you.
Okay, thanks. First item is 0400. It's action on an inspection of San Francisco International University College of Law. This school is a for-profit registered unaccredited correspondence law school, first registered with the Committee of Bar Examiners in 2017. A condition of registration was that the school undergo an inspection within 2 years of starting operation. After several extensions requested by the school, an inspection was begun in December 2020, but not completed until roughly 6 months later due to technical difficulties and incomplete information. None of the school students have passed the first-year law students exam, though one was awarded a JD degree, but was found ineligible to take the California bar exam because of he hadn't gone through the first-year law exam prerequisite. The staff report catalogs many points of failures to satisfy the requirements applicable to the school. At present, the dean and owner, it's one person, cannot be reached, and the school may have closed, but we have no official confirmation of that fact. The recommended action is to receive and file the report and adopt its recommendations. Further, to direct staff to issue a warning letter to the school to take immediate corrective action and provide notice of the corrections within 30 days of the issuance of that warning letter. And finally, provide notice to the school that this committee believes that the school is out of compliance with the unaccredited law school rules and that the committee intends to pursue probation or termination if the school does not demonstrate compliance. Does anyone have any questions? So we can go into more details, but like I suggested, the list of deficiencies is rather long, and unless somebody wants to go through a particular one of interest, we'll leave it at that. So are there any questions? Natalie, you want to put the motion on the screen?
Sure, I'm happy to do that, Paul. It may be helpful to know that the school has not filed its annual compliance report or paid its annual fee and has not responded to requests to do so as well.
Okay, so if there are no questions, does somebody want to make a motion?
I'll make the motion. This is Kareem. I'll second if Mr. Torres.
Okay, I'm sorry. So who made the motion? Mr. Gongora?
Mr. Torres.
Oh, Mr. Torres, okay.
Kareem did the second.
Got it. Thank you. Dr. Bolton?
Yes.
Judge Brody? Dr. Cow?
Yes.
And yes on Brody.
Okay. Mr. Chen?
Yes.
Mr. Efting? Mr. Gongora?
Yes.
Ms. Heisinger?
Yes.
Judge Herman?
Yes.
Mr. Iseri?
Yes.
Mr. Kaplan? Mr. Kramer?
Yes.
Mr. Reyes?
Yes.
Mr. Torres?
Yes.
Dr. Wilkinson?
Yes.
The motion passes.
Okay, thank you. What's my notes? The next is item B, or 0401. This is action on an inspection of American Heritage University School of Law. This school is a for-profit, registered, unaccredited distance law school. After several extensions and multiple attempts to submit a self-study, an inspection was conducted in December of 2020. Like the previous item, the inspection report identifies multiple instances of noncompliance with the bar's requirements. And the recommended action is similar: to receive and file the report and adopt its recommendations. Further, to direct staff to issue a warning letter to the school to take immediate corrective action and provide notice of the corrections within 30 days of the issuance of the warning letter. Finally, to provide notice to the school that the committee believes that the school is out of compliance with the unaccredited law school rules, and that the committee intends to pursue probation or termination if the school does not demonstrate compliance. And I do note they have filed a bit of a response to some of the issues that were identified in the inspection report, but it certainly doesn't respond to all of them. And Natalie, has staff even had time to consider that response and determine what it portends?
Martina?
Yes.
Hey,
Staff,
hi, it's Judge Brody.
I think we need to mute.
What's
Robbie.
happening?
Can we mute Robbie, please?
Staff has reviewed the response. It does indicate compliance in administrative areas where compliance was quick. The major issues identified are generally listed as pending. So it was considered in creating the staff memo.
Okay. Does anyone have any questions about this? Okay, Natalie, you want to share the? You might as well just keep them on the screen and just scroll through them. So does anyone wish to make a motion?
I move.
And that's the recommended motion on the screen?
Yes.
That was
Is there a
Dr.
second?
Wilkinson.
Second.
I'm sorry, who's second?
Torres.
Okay, thank you. Dr. Bolton,
Yes.
Judge Brody, Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting, Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Judge Herman,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan, Mr. Kramer,
Yes.
Mr. Rios,
Yes.
Mr. Torres,
Yes.
Dr. Wilkinson,
Yes.
the motion passes.
Thank you. Next is item C, or 0402. Sorry, 0402. Pacific Coast, it's an action on a major change for Pacific Coast University School of Law. They are seeking ratification of a reorganization of their JD program from quarters to a semester schedule. This was on our October agenda, but was put over until this meeting to allow staff to evaluate some information that was provided by them just before the October meeting, and which appeared to conflict with some earlier provided information. Staff has since evaluated that information, and while some questions remain, staff is recommending that we approve the request and impose a timetable for resolving the remaining questions, and that compliance be reviewed during the periodic inspection of the school that is scheduled to occur in the normal course in 2022. So the staff's recommendation is that we receive and file the school's request, grant the request subject to further review during the school's next inspection, and require that the school submit by January 31st of next year the deliverables that you'll see in the second paragraph of the motion that's on the screen, and advise the school to timely file requests such as this in advance of implementing a requested action. I believe it was the first part of this week, Pacific Coast University emailed responses to staff. As before, staff hasn't had time to evaluate the new information, so they can't say at this point to what degree it might address the questions that they have. But it may ultimately be found to demonstrate compliance with our rules. We're just hard pressed to resolve that today. Rather, I suggest that we adopt staff's recommendation and allow the process of reviewing the compliance to go forward. In its cover email to Ms. Leonard, the school asserted that they did not think that this kind of change should require a major change petition. Staff disagrees, and in my view, at least, the existence of the questions that staff poses demonstrates that such a change should be the subject of a review before it's implemented via a major change request, if for no other reason than to assure that the modified course of study will qualify students to take the bar exam. We can, of course, bring this question about whether a change from quarter to semester schedule should require a major change petition for discussion at a future meeting if the committee is interested in doing so. But I don't think we can litigate that today with the information that's before us. You have the recommended motion in front of you. Does anyone have any questions or comments?
I do. So getting back to this was effective fall 2021. So they, for the most part, are in a semester setting now.
Yes, they implemented it in the fall.
And this is, Natalie, this is something that there's no other action, just to make sure that they file everything that's needed.
Right. So they were advised in June to file the motion in advance. They were unable to do so given the schedule, and but they have provided the information since.
Okay, I'll move in agreement with the recommendation.
I'll second.
Thank you. Dr. Bolton,
Yes.
Judge Brody, Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting, Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Judge Herman,
Yes.
Mr. Isari,
Yes.
Mr. Kaplan, Mr. Kramer,
Yes.
Mr. Rios,
Yes.
Mr. Torres,
Yes.
Dr. Wilkinson,
Yes.
the motion passes.
Okay, the next item is D. That's 0403. That's another major change request from Irvine University College of Law to change their unaccredited category from a fixed facility learning law school to distance learning. Their dean, George Leal, talked about this during public comment this morning. They are requesting, again, a change of the status from fixed facility learning to distance learning to take effect on July 1st of 2022. The staff analysis describes the steps that will be necessary to achieve this change, and they recommend that we receive and file the request and provisionally grant it, subject to the school providing various deliverables on a specified timetable. As Dean Leal mentioned, the original motion and proposed approval would have provided for a single deadline for providing the information. But as he said, he thinks it's going to be more practical for them to do this in stages. And so they've asked that the schedule be modified to include 3 staggered deadlines to allow it to create the new program elements and stages beginning next summer and then continuing over the following class terms. One aspect to note here is they are intending to give credit for bar preparation classes. That is currently allowed under a waiver that this committee approved at least 10 years ago. Do you remember the year even, Natalie?
2009.
Okay, so it's more than 10 years ago. What we may be doing next year is reviewing whether that waiver should continue. And Natalie has discussed it with the school, and they understand that if it is rescinded, then they'll have to revise their program to account for that. You have the proposed motion on the screen.
Do you want me, this is the proposed with the additional due dates next year.
Yeah, this is the staggered one, right?
Yeah.
Correct, and it represents the deadlines that the school asked for. They initially asked for the first deadline, and then upon building out the schedule, asked for more flexibility. It may be helpful for for the committee to know that while the school is small, they are affiliated with a larger university, Westcliff University, informally, and they will have the assistance of that university in creating the distance courses.
Any questions from anyone? Does anyone wish to make a motion?
I'll move.
Is there a
I'll
second?
move.
I'll second.
Is that Mr. Rios?
No, I think that was Mr. Aseri.
Yes.
Oh, okay, thank you. Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Judge Herman,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan, Mr. Kramer,
Yes.
Mr. Rios,
Yes.
Mr. Torres,
Yes.
Dr. Wilkinson,
Yes.
the motion passes.
Thank you again. The next is item E, or 0404. It's an action on another major change for Humphreys University Drivon School of Law. They propose to teach their students via a blended, simultaneously online and in-person program. Unlike the temporary pandemic extensions that we are going to be discussing shortly, this would be a permanent change to their program. Some students would be in the classroom, others would be participating with those students via voice and video link. This would give the students the option to attend class in the way that best suits their individual circumstances. Some might be mostly online, others mostly in the classroom. If they had a last minute emergency, for instance, then they wouldn't have to spend what can sometimes be a considerable amount of time commuting to school that day. So it provides them with flexibility. Drivon is an accredited law school, which is also accredited by WASC. It has 70 students in its JD program, and its most recent NPR was 52.3%. Staff recommends that the committee receive, file, and grant the request. Any questions?
So move.
Second.
I'm sorry, who moved?
Kareem, and was that Mr. Torres?
Second. Yes.
Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Judge Herman,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan, Mr. Kramer,
Yes.
Mr. Rios,
Yes.
Mr. Torres,
Yes.
Mr. Wilkinson,
Yes.
the motion passes.
Next is item F, 0405. That's action on a major change and waiver for the University of Laverne College of Law. There's 3 requests here. First is a temporary waiver to teach online through August 15, similar to the group of requests that we're going to be discussing soon. That request is combined with the request to permanently remotely teach up to 3 weeks per semester. And then an additional request to teach up to 3 elective courses each semester in an online format. They found during the pandemic that by not having to require subject matter experts to come to the law school to teach elective, specialty classes, that it's been easier for them to attract quality faculty members and provide a wider range of potential experiences for their students. So they're hoping to continue that process even after the pandemic ends and those temporary waivers are no more. Staff is recommending that the committee receive, file, and grant the requests.
So move.
Can you please state your name for the motion?
Wilcoxon, so move.
Thank you.
Reyes, second.
Thank you. Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Judge Herman,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan, Mr. Kramer,
Yes.
Mr. Rios,
Yes.
Mr. Torres,
Yes.
Dr. Wilkinson,
Yes.
the motion passes.
Okay, next is item G, as in George, or 0406. Another major change from Cal Northern School of Law. They're requesting our approval of teaching of both their JD program and their Master of Legal Studies program synchronously online and in person. Like I described earlier, that's where some people are in the classroom and others are phoning it in is the wrong phrase. But anyway, they are appearing and participating in that same class at the same time via audio and video links. Their curriculum will not change, just the method of delivery, which to this point has been in person only, except for during the pandemic. Staff recommends, and we are acquiescing in the change to their Master of Legal Studies program because our rules say that when a law school is also offering other degrees, other professional degrees, that we need to be informed of those programs and acquiesce to the point of making sure that the other program will not impinge upon the JD program in some way that makes it less effective. But to be clear, we are not approving the Master of Legal Studies program beyond that. We're certainly not reviewing its the details of its content or any other aspect of it, just that it's not going to cause problems for the JD program. That is our main focus. So staff recommends that the committee receive, file, and grant the request and acquiesce in regarding the JD program and acquiesce in the change to the MLS program. Any questions?
Paul, this is Robbie. Is there some concern that there's going to be confusion among students between those programs and preparation to sit for the bar exam?
I wouldn't think so. I mean,
Oh.
Natalie, doesn't their catalog make it clear that the Master of Legal Studies is not qualifying one to take the bar?
That's correct. There's actually a specific disclosure that the students must review and sign to understand that that's the case.
But it is a law school, right? It identifies itself as a law school.
Well, but
Yes,
even ABA schools also sometimes have, Master of Laws degrees, LLMs, and that sort of thing that I think it's understood in those cases, those don't qualify you to take a bar exam. So it's normal.
Okay, I'm just concerned that my at first blush concern was that a student might be misled into thinking that they were paying for and taking something that would entitle them and prepare them to sit for the bar. But if you two are confident that that confusion is not the case, then I'm certainly, I'm glad I asked.
It sounds like we've required everything we can to make sure that they know better, whether they read in and adopt, actually understand the materials well. You can only do so much.
Natalie, what possible purpose could there be for that other degree?
For that master's, a couple of possibilities. Historically, until the committee made a change requiring students with a foreign first degree in law to attend an LLM program, it could have been used for bar qualification for someone with a first foreign degree in law. It would now be up to the school to create an LLM. A second possibility could be that the person has interest in a policy purpose, policy analyst rather than an attorney. A third possibility, this school is also approved by WASC, and if a student takes a joint MLS JD degree, they may qualify for federal financial aid for the first 2 years of their 4-year study. So those would be the top 3 reasons. And you do raise an important point that it is critical for the student to understand what eligibility they can ultimately achieve. And that is why we have the disclosures, because you raised a very important point.
Okay, thanks, Natalie.
You're welcome.
And thanks, Paul. And I'll having fleshed all that out, unless anyone else has any comments, I will make the motion to approve that that request.
Second. I'm sorry.
Go ahead.
Torres jumps the gun again.
That was Torres on the second.
Thank you.
Yeah, really.
Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr.
Yes. Jumping the gun.
Thank you. Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Judge Herman,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan, Mr. Kramer,
Yes.
Mr. Rios,
Yes.
Mr. Torres,
Yes.
Dr. Wilkinson,
Yes.
the motion passes.
Okay, now we come to 10 requests, items H through Q, or 0407 through 0416. Each of these schools is requesting a further extension of the ability to teach their courses online, due, of course, to the continuing uncertainties related to the COVID pandemic. The only points of difference are the new proposed expiration dates of the extensions, and the motion for Lincoln Law School of Sacramento describes their teaching program as synchronously online and in person, because we previously approved that program feature. On the screen now is a table showing all the schools. They're all fitting. Yes. And the new end dates for the extensions that are proposed by the various motions. So I propose that we take them all together, given the similarities as a group with one motion. Does anyone object to doing that? Or does anyone have any questions?
I don't object, but giving this some thought, it looks as though now with the Omicron that we've got coming, all these mutations, I think this is going to become part of the future. And at what point do we need to continue doing this? Are they going to have to make a formal request to allow this to keep on going? Something indefinite?
At this point, the thought would be that after this waiver period, schools that wanted to continue would make a formal change, because you made your original blanket waiver now back in 2020. So they would have had 2 years to make a decision, and they will have had examples by the summer of schools that have gone back in person. You've got an example with your Chair Lawrence, his school going back in person, those that have done it in blended format, and those that have gone online. So it should be sufficient time for them to make a permanent decision, and you saw several make that today.
Thank you very much. I have no objection, and I'm prepared to move for the waivers.
All 10 motions?
Yes, please.
I'll second
I'll
that,
second
Mr.
the
Brody.
Thank you, Judge Brody. Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Judge Herman,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan, Mr. Kramer,
Yes.
Mr. Rios,
Yes.
Mr. Torres,
Yes.
Dr. Wilkinson,
Yes.
the motion passes.
Okay, final item is R, the approval of the report on the 2021 to 2022 educational standards goals. I'll just highlight that for next year, we're going to begin the process of reviewing the rules and then ultimately the guidelines relating to unaccredited schools. I think it suggests that we're not sure if we need to make changes, but I can tell you that I think there for sure will be some, whether they're small or large remains to be seen. And I understand that some of the schools are also interested in making some changes to the rules. So I suspect that will move forward. It might be a multi-year process as the review of the accredited law school rules were, but the sooner we start it, the sooner we can get some movement going. And you might see the last goal, which suggests or talks about moving all the unaccredited schools to accredited status, and wonder why we are talking about changing rules that might be irrelevant in a couple of years. And I think the answer is that so far that movement to move them to accredited status has gotten about zero traction. And so it's not clear that that is ever going to go anywhere. And we haven't given ourselves any deadlines to miss there either. It's still on the list, but I personally wonder if that's ever going to come to anything. So with that, are there any other questions or thoughts about the goals or a motion?
Wilcox, Mike.
Oh, go ahead.
Go ahead.
Thank you. This is Mike. I'd like to go ahead and make a motion for that.
And this is Wilcox, and I'll second.
Thank you. Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Judge Herman,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan, Mr. Kramer,
Yes.
Mr. Reyes,
Yes.
Mr. Torres,
Yes.
Dr. Wilkinson.
Yes.
The motion passes.
Thank you, Ms. Wong. Thank you, Mr. Kramer. We have one more item, and then I recommend that we break for lunch. So we're going to move on to moral character with open agenda item 500, approval of the report on 2021-2022 moral character goals. I'll turn it over to you, Mr. Reyes.
Yes, regarding the moral character goals, similar to last year, there are a number of trainings involved. We just had one today. An upcoming one will be on reviewing relevant cases and determining moral character. There will be future ones spread throughout the year on ethics training, client trust accounts, and other accounting and other training as we see relevant throughout the year. But the main thing is the ongoing administrative reviews that happen, once or twice a month. And many of you in the committee are involved in that. So those are the goals. And I guess we would look for the motion to move these.
Yes, this is Brody. I'll move to approve those moral character goals. Thank you, Vince.
I'll second.
Second by Dolores Heisinger. Hey, Dolores.
Hi.
Thank you. Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger, Judge Herman,
Yes.
Mr. Iseri.
That was
Yes.
a mute yes.
Thank you, Ms. Heisinger. Mr. Kaplan,
Yes.
Mr. Kramer, Mr. Reyes?
Oops, yes.
Thank you, Mr. Kramer. Mr. Reyes?
Yes.
Mr. Torres?
Yes.
Dr. Wilcoxen?
Yes.
The motion passes.
Thank you, Ms. Wong. And it's now 11:45. Let's break for lunch and return back at 12:15 in closed session for the committee members. You should have all received a message with the link to go into closed session. And at that time, we'll start off with the chair's time and a report from council. So again, look forward to seeing all of our members back in closed session at 12:15. Thank you.
Mr. Chair,
Yes.
can you please, you state that the meeting will be, the open session will continue on to Saturday?
Sorry, thank you. Yes. So the open session will continue on Saturday as stated by Ms. Wong. Thank you, everyone. See you back at 12:15.